Chapter 2, School-to-Guardianship Pipeline for Youth with IDDD, page 31. There are two excerpts in the middle of the page. The first one says, however, under IDEA, the transfer of rights to make one's own education decisions will not occur if the adult student is subject to guardianship. The second one says, school professionals may be biasing parents toward pursuing guardianship because of the way in which they notify them of the transfer of rights process. School-to-Guardianship phenomenon. The Individuals with Disabilities Education Act, IDEA, generally requires once students in special education reach the age of majority, usually 18, depending on state law, the school to transfer all of their parents' educational rights to them as part of the transition planning process. When that occurs, students have the right to make their own educational decisions for as long as they are entitled to receive special education services, i.e., until they graduate from high school or exceed the maximum age for receiving special education, services which in most states is 21 years old. However, under IDEA, the transfer of rights will not occur if the adult student is subject to guardianship. The transfer also will not occur if the school uses a separately established non-judicial educational representative process to determine that the students cannot provide informed consent to educational decisions and to appoint another person, usually a family member, as the adult student's educational representative. It is often at the transfer of rights juncture that many parents and school personnel question the competence of students with disabilities, and parents seek to become the legal guardian of their young adult children. At this point in the IDEA transition process, guardianship can be set in motion by a variety of factors. First, intentionally or unintentionally, school professionals may be biasing parents toward pursuing guardianship because of the way in which they notify them of the transfer of rights process. For example, they may start the conversation by asking parents if they have guardianship or are planning to obtain guardianship, rather than discussing the student's strengths and abilities and less restrictive options of decision-making supports, such as SDM or educational powers of attorney. Page 32. In the center, excerpt says, such extrajudicial processes raise due process concerns in that rights are being taken away from the student without court adjudication. Additionally, school personnel might not be aware of alternatives to guardianship or its legal impact. As one former educator explained, I recall hearing the department chair and others saying that if the student does not have a guardian, then the parents cannot attend the meetings and it just makes things more challenging. I was not told about alternatives to guardianship. Such conversations may pressure parents to pursue guardianship over their adult child so that they are assured they can continue to be involved in their child's education. While IDEA does not require appointing a guardian for adult students in special education, it allows and arguably mandates states to establish alternative procedures, short of guardianship and consistent with state law, for the appointment of the parent or another person to represent the educational interest of an adult student. If the school district determines that the student is unable to provide informed consent to his or her education program, such extrajudicial processes raise due process concerns in that rights are being taken away from the student without court adjudication. They also promote substitute or surrogate decision-making rather than SDM in the educational context based on a 2012 review of state law and regulations. At least 6 states had regulations that expressly provided for a non-judicial appointment of an educational representative for the student upon parental request and/or professional certifications, or an individualized education program, IEP, team finding that the student is incapable of providing informed consent for educational decisions. Page 33. There are 2 excerpts. The first one The majority, 58% of people with IDDD ages 18 to 22 receiving publicly funded services have guardians. The second one says, a 2015 study supported by the TASH Human Rights Committee found that schools were the #1 referral source for guardianship. The District of Columbia joined them in July 2016, as discussed in Chapter 5. Some states have other exceptions to the transfer of rights. In Maryland, for example, the general rule is that parents retain the special education rights of their adult child, unless they affirmatively or tacitly refuse or fail to participate in the special education decision-making process. There is no national data available on how many people with IDDD get guardians right after high school. However, 2015 to 2016 National Court Indicator Survey data indicates that the majority, 58%, of people with IDDD ages 18 to 22 receiving publicly funded services have guardians, which suggests guardianship is common for this age group. Moreover, as highlighted in the 2018 NCD report, stakeholders frequently reported that guardianship is presented by the school system as the main, if not only, option for decision-making support for young adults with IDDD. A 2015 study supported by the TASH Human Rights Committee found that schools were the #1 referral source for guardianship, and guardianship is frequently considered the default option for students with IDDD. Many of the stories NCD collected affirm this. A professional who used to work with transition-age youth in special education reported that she and her colleagues would give parents what was known as a guardianship packet. She said, "It makes me cringe now that that is how it was being passed around school, how nonchalant it is, and then how dangerous it can actually be. I didn't experience from my mentors that this was a human rights issue, that you were contributing to, taking someone's rights away by recommending guardianship. Parents see you as a representative and professional on behalf of the district, so if you say something like, 'Here is information on guardianship,' then they may not do their due diligence." As a Michigan family member reported, too often schools have told family members that a student with IDDD must have guardianship if they want a family member or friend to assist with one's IEP when the student turns 18. School districts are terribly misinformed about guardianship and use this approach to limit families' involvement in IEPs. A Massachusetts family member reported, "People are encouraged by well-intended educators to make the decision about guardianship at the age of majority." Page 34. These educators do not connect the dots between transition when they should be teaching decision-making skills and the notion that guardianship is contrary to what they are supposed to be accomplishing. A person with IDDD in Virginia said guardianship happens at 18 because schools tell parents they have to have guardianship to make school and IEP decisions for and with their child. When people assume someone like me, who doesn't walk or talk, is stupid and needs to be put away and to make all the decisions about me for me. A family member from Kentucky said, "In my family's experience, we were prompted to begin the processing of obtaining guardianship. During his special education case conference meetings while he was still in high school, the school was not terribly helpful in informing us of the process, but did provide resources for where to go for more information." A Missouri family member reported, "It was recommended at my son's 18th birthday by the school officials that I file for guardianship." Many stakeholders also reference the lack of information on alternatives to guardianship provided by schools and its impact. For example, a family member reported, "Forms of limited guardianship were not discussed in IEP team meetings, as it was assumed my brother with IDDD would require plenary guardianship." A family member in Michigan responded, "Very, very little information on this from schools. Too often schools have told family members that a student with IDDD must have a guardianship if they want a family member or friend to assist with one's IEP. When the student turns 18, school districts are terribly misinformed about guardianship or use this approach to limit families' involvement in IEPs. A guardian in Missouri responded, "The educators do not support alternatives to guardianship." A lawyer in Indiana said, "There is no information available from the school. Our protection and advocacy organization has a website and will do information presentations." Stories of the school-to-guardianship pipeline. A person with IDDD in Virginia said guardianship happens at 18 because schools tell parents they have to have guardianship to make school and IEP decisions for and with their child. When people assume someone like me, who doesn't walk or talk, is stupid and needs to be put away and to make all the decisions about me for me. Page 35. There are two excerpts. The first one, if states' educational systems are promoting guardianship without appropriate consideration of less restrictive alternatives, including support decision-making, they are arguably violating the ADA. The second excerpt, for young adults with IDDD, the guardianship may be an obstacle to the development of self-determination skills necessary for life after high school. The impact of the pipeline and U.S. policy implications. Youth with IDDD are ultimately disempowered by schools actively encouraging guardianship to the exclusion of less restrictive alternatives and not providing families and students in special education with sufficient information about the availability of a full continuum of decision-making supports. Research has found reduced self-determination can lead to diminished quality of life, outcomes in reduced community integration and participation. For young adults with IDDD, guardianship may be an obstacle to the development of self-determination skills necessary for life after high school, such as critical thinking, self-advocacy, and knowledge of one's own skills, interests, strengths, and weaknesses. Studies have found that students who have self-determination skills are more likely to successfully make the transition to adulthood, including improved education, employment, and independent living outcomes. Studies also have found that the appointment of a guardian for a young adult with IDDD did not necessarily resolve the areas of concern, prompting it, and in some cases, the young adult under guardianship would have done just as well, if not better, without a guardian. The guardianship often appeared to have benefited the guardian rather than the person under guardianship. The U.S. policy implications of the school-to-guardianship pipeline are also troubling. There are strong arguments to be made that it runs contrary to important civil rights laws impacting people with IDDD. As the 2018 NCD report found, guardianship must be seen as subject to the Americans with Disabilities Act, ADA, which has been interpreted by the U.S. Supreme Court in the 1999 Olmstead decision to give rise to an obligation to provide services to people in the least restrictive environment that will meet their needs. If states' educational systems are promoting guardianship without appropriate consideration of less restrictive alternatives, including supported decision-making, they are arguably violating the ADA and promoting outcomes that run contrary to the Olmstead Community Integration Mandate. As one interviewee stated, by definition, if you are not the person making decisions, your ability to be a real member of the community is smaller. In addition, while there may be traces of guardianship found within it, IDEA also mandates individualized transition planning for qualified students with disabilities to increase the likelihood of post-school employment and/or education. Transition planning outcomes should be tailored to students and their individual preferences, needs, and strengths, so they should contribute actively to the decision-making and planning process. Page 36. Two excerpts. The first one, the goals of transition planning, which focus on autonomy and independence, appear to be in direct conflict with the goal of guardianship, which is to facilitate the individual's dependence on another person's authority to make all or some of their decisions. Excerpt 2. NCI data indicates people with IDDD who receive publicly funded services who are not under guardianship are more likely to be employed in an integrated job. With that in mind, some scholars have suggested that the goals of transition planning, which focus on autonomy and independence, appear to be in direct conflict with the goal of guardianship, which is to facilitate the individual's dependence on another person's authority to make all or some of their decisions. As one team of researchers observed, guardianship can work against the goals of transition planning because it has broad implications regarding the loss of fundamental rights and personal liberty. Moreover, the purpose of the Federal Developmental Disabilities Assistance and Bill of Rights Act is to assure that individuals with developmental disabilities and their families participate in the design of and have access to needed community services, individualized supports, and other forms of assistance that promote self-determination, independence, productivity, and integration and inclusion in all facets of community life. These goals are likely more readily achievable through alternatives that hold the promise of increasing self-determination, such as supported decision-making rather than substitute decision-making, as one prior NCD interviewee stated. Guardianship is never going to allow the person subject to it to really become integrated to the community because others are going to have to be always checking with the guardian, not the person. Finally, one of the goals of the Rehabilitation Act of 1973 is to promote and support employment for people with disabilities, including IDDD. Its regulations have long recognized the importance of intervening early in the lives of transition-age youth with disabilities by mandating that state vocational rehabilitation programs coordinate with special education transition teams as early as possible. The Workforce Innovation and Opportunity Act, WIOA, further augmented these requirements by mandating vocational programs to provide pre-employment transition services to assist students with disabilities make the transition from secondary school to post-secondary education programs and competitive integrated implement. In addition, Section 511 of WIOA was designed to make it less likely that youth who have disabilities and are age 24 or under are inappropriately rooted to segregated sub-minimum wage employment without first exploring all the alternatives for meaningful work and post-secondary education and training. Page 37. Research has found young adults with disabilities who are supported have greater self-determination in their lives, are more likely to be better employed, and National Core Indicator data indicates people with IDDD who receive publicly funded services who are not under guardianship are more likely to be employed in an integrated job, and those who are in guardianship are significantly less likely to have employment as a goal in their service plans. Both of these findings suggest the Rehabilitation Act's and WIOA's goals may be better achieved by requiring schools and transition teams to ensure awareness of decision-making support options that do not remove the legal rights of young adults with disabilities. It is therefore critical that the school-to-guardianship pipeline be dismantled so that students with disabilities and their families receive the information they need to make thoughtful and informed choices when it comes to guardianship and alternatives. As one former educator noted, too often, students are not informed, parents are uninformed, and educators are uniformed. It's a triple whammy. Fortunately, efforts to address this information gap have been undertaken by the U.S. Department of Education Office of Special Education and Rehabilitative Services, OSERS. In January 2017, OSERS issued its Transition Guide to Post-Secondary Education and Employment for Students and Youth with Disabilities report, which recognized the serious implications of guardianship and encouraged schools to recognize and promote support decision-making and self-determination by students before, during, and after the age of majority. It also recognized other alternatives to guardianship in the educational context, including educational powers of attorney. OSERS archived and then updated and reissued this guide, retaining these important elements of its guidance. However, based on the information received from respondents as part of this project, more is clearly needed to ensure that the teachers, schools, and school districts are complying with this guidance. This should include revision of all teacher education and certification programs and vocational, the full rehabilitation agencies to include training on range of decision-making options for students who have reached the age of majority. As one former educator said, being a first-year teacher shouldn't be the first time that I am learning about age of majority and guardianship and alternatives. If the district itself is unaware of or has varying views of students' abilities to lead independent lives, then you are at the mercy of the vision of the school. The universities are in a powerful position to prime the teachers, training parents for school-to-adult transition and alternatives to guardianship. As one parent said, when it comes to guardianship and alternatives, you don't know what you don't know. Promotion of self-advocacy and self-determination at an early age for students in special education. As one former educator said, schools have the power to promote self-determination as early as possible, and that can be done by empowering the students to lead the IEP and other meetings. It puts them in a position of leadership and empowers them to take an active role. Page 38. If the student has been passive throughout their entire education, maybe not even attending the meeting, how would the team even know if the student could make a choice if they are not even empowered in participating and attending the very meeting that is planning their education?